your indulgence, we're handing out all the substitutes and amendments so the committee will have it in front. If we could take roll of the subcommittee, please. All right, I think a quorum is present. Is Plum, Delegate Plum? All right, we have a quorum, so let's go ahead and proceed. There's lots of places that people need to go. I'll take the chairman's prerogative, and I'd like to call up Delegate Sullivan first for House Bill 1582.
Thank you, Mr. Chair. Members of the committee, good morning. As the chair noted, this is HB 1582. It involves compensation to David Kingrey under our well-established statutes here in Virginia for compensating Virginians who've been found to be wrongfully incarcerated. Briefly, I think the bill sort of speaks for itself, but Mr. Kingrey was convicted in 2014 of taking indecent liberties with a minor, maintaining his innocence throughout the whole process. He eventually served 1 year in jail, continued to maintain his innocence after leaving prison. 6 years later, the minor who had made the accusation had by then grown up, was an adult, and himself had become incarcerated. And I think the quote was, having now understood what he put Mr. Kingrey through, recanted his testimony, indicated that he had made it up. So there was a process, the process initiated available to all Virginians to seek a writ of actual innocence. That process played out. Judge Turk, who had tried the original case, familiar with its facts, held an evidentiary hearing. The recanter testified. Judge Turk reported to the Court of Appeals, as is the process, that he was convinced that indeed the original trial testimony had been fabricated. And last year, just a few months ago, actually, I think the Court of Appeals did in fact issue a writ of actual innocence. So under our process, a writ of actual innocence, a claimant can come to this body and seek compensation. These cases, you all know I've done a number of these, unfortunately, and they all have, they're just terrible stories. You're going to hear another one right behind me. I will say that the numbers shouldn't matter. The numbers are what they are. Mr. Kingrey was wrongfully incarcerated for a year. I was going to say only a year. For a year. It's a long time. There's another element to this case I want the committee to understand. It also resulted in Mr. Kingrey being on the sexual offender registry for 8 years until his writ of actual innocence. And he's here. He's going to tell you a little bit about that. But being on the sexual offender registry, of course, precluded him from, he couldn't get the job back that he had beforehand. He applied for a couple jobs, couldn't get those because he's on the registry. And to him, he's going to tell you this, perhaps its even more important effect was he has a young son named Dylan who actually has a couple of very rare diseases that he's challenged with. Mr. Kingrey was not even allowed to go to his school. He couldn't get anywhere near a school and all those sorts of things. So my point simply is, Mr. Chair and members of the committee, that these kinds of wrongful incarcerations have profound impacts on someone's life. And that's why the legislature decided years ago that while compensating them with money can't give back the time and the lost opportunities, it's how we do it. It's what we do. And with that, I will simply ask the committee to favorably consider HB 1582.
All right. Thank you, Delegate. I will note that there are amendments, line amendments, technical mainly.
Second.
All right, we have a motion to accept the line amendments. So all in favor say aye.
Aye.
All right, so the bill properly amended is before us, and I think Mr. Kingrey is online. Is that correct? So if you,
yes, sir.
Yes, sir. You have the floor.
Hello, and good morning to everyone. I don't know exactly how this process goes, but I would like to thank you for the time that's given to me. It's definitely a very exciting opportunity. Almost 12 years is a very long time. to well, that would be the first time that I had spoken with the detective. 12 years exactly this coming October. And as Mr. Sullivan stated, um, uh, it's been very emotional journey. It's not always about the individual. There's other lives that it's been affected, and I really could go and say lots of things, but I think the main thing to take into consideration is, like you said, I have my son Dylan, and he'll be 8 in April. And while I was incarcerated, I actually got a week furlough to be there for the birth of him. Uh, about a few months after his second birthday, he started having seizures. And unfortunately fortunately now he hasn't had a seizure in about 7 months. But he's got many health impairments, 2 rare diseases, Lennox-Gastaut syndrome and creatine transporter deficiency. And like Mr. Sullivan stated, it has been not only the effects of trying to not being able to go to school, but the effects of his overall care. To put it into terms, I was asked to try to put this into words, and I couldn't really think of any. But this right here, if everyone has something that they hold dear, that they care about, and if you would think about it just for a moment of how it would impact you if the worst thing that could happen would happen. That's really the feeling that I have, because not being able to control. It's one thing to be put in a situation that you can control, but it's a whole different meaning when you're placed here under false pretenses and chose down there, because I did have a good job with benefits, and I would have been able to provide a better home for Dylan, because he's so where there really ain't no words. He's nonverbal. He's a high risk of elopement. We live really close to, I call it the Autobahn. It might as well be. It's a major highway, but he has to sleep in an enclosed bed. This is really and truly the heartbreaking part of this. It's not about me. It's about the Commonwealth of Virginia took me away, and they left me hanging out to dry. Really, if it wasn't for the good nature of these individuals that are standing in front of you and abroad, I don't know where I would be. But I just ask that I just need the compensation for one thing and one thing only, and that's to provide a home for my son so he could stay with us. I can't express it enough how heartbreaking it is to watch him. I've seen him have 154 seizures in a day, and I've been, we have fought and we fight, and but to know that no one has a blessed assurance of any of days on this earth, but to know his conditions definitely limited his years on this earth, according, to his other peers. I want his life to be as happy and healthy and safe as possible. And this would be a great start to have be awarded the year of compensation. But the years, 26 court appearances before I was even on trial, maintaining after I was looking at 80 years, I've always stood on the truth. And even my friend, Mr. Kellerman, the lawyer, thought we had lost it. I said, we've never lost it. Went into overtime. And right here is the first day that, thank you for the opportunity, because this is the exciting moment for me, because I know that we're actually going to be able to start at least getting him a place here put on our land that would keep him home, keep him safe. And I don't want to take up no more of your time.
Mr. King, yeah, thank you so much for the testimony, and all, about the only thing we could say is, we are sorry for everything that has happened, and I hope this will be just I hate to say it's a token, but it's the process that we've got set up. So we're so
Yes,
sorry,
sir.
and we will take motions on the bill.
Thank you.
I second that motion with amendments.
All right, so with the bill, House Bill 1582 is properly before us, properly amended. All in favor, we'll go to the voting board. The bill reports 8-0.
Thank you, Mr. Chair, members of the committee. Appreciate your time.
And at this time, I'll take the prerogative to bring up Delegate Ware, House Bill 1463.
Thank you, Mr. Chairman, and I will simply say this is the first time I've had a bill of this nature. I think it's pretty well self-explanatory. It is in relief on behalf of Michael Haas, who was wrongfully incarcerated with a conviction that has subsequently been noted to be wrongfully done. So, Mr. Chairman, that's what I have, and I'll be glad to add to that as you
Thank you,
need.
Delegate Ware. I think there are line amendments.
Mr. Chairman, I move the amendments.
All right, the line amendments have been properly moved and seconded. All in favor of the line amendments, say aye.
Aye.
So the bill is properly before us. Delegate Ware, is Michael Haas in the room? Would like to
I am told that
speak?
he is here in some fashion. Right, yes, yes, indeed, yes, sir.
And if he would like to have a few minutes, sir.
Okay. Nice to meet you.
Ladies and gentlemen, thank you for your time here. Allow me to speak. My name is Michael Haas. I spent over 23 years in prison for a crime that never happened. From the very first accusations and all through my case, I proclaimed my innocence. These years in prison came with many heartaches and pain. I have seen things and experienced things that were and still are very troubling for me. Being in prison with a tag on my back as a child molester was not easy to handle. Many other prisoners and gangs tried to extort money from me for protection, but I refused, which resulted in many fights. To be honest, I lost a few and won a few. In prison, a man has only one thing, and that's his word. Since I refused to pay for protection and stood my ground, my word was good, and I was respected for that and eventually left alone. The life of Joseph from the Old Testament of the Bible is very similar to my time in prison, as God showed him favor as he spent his time in prison for a crime he did not commit. God also showed me favor. I lost my father while I was in prison due to stress he suffered from worry over me being incarcerated. My mother fought for my innocence from the beginning, but she died a few months before I was exonerated. She was 96. I would like to say that this case destroyed my children's lives. They are still traumatized and very distant. I do have a good relationship with my daughter and my older son. I must give thanks to God for all his favor, Mid-Atlantic Innocence Project, which is especially Julie Dahlberg, my new attorney, Emily Hosberg, my mother and father, and my sister, and for every one of you. I come to you today not to tell you my life story, but to thank you for your compensation of my wrongful incarceration. Thank you for everything, and I can only wish you the best for you and your family. Does anyone have any questions?
Thank you, Mr. Haas. We're certainly sorry for the time lost.
Thank you.
So,
Mr. Chairman,
yes, sir.
Mr. Haas, we apologize.
Thank you.
We know this had to be traumatic and difficult for your life, and I just want to personally tell you, the Commonwealth's sorry.
Thank you.
Thank you.
I'll entertain a motion on House Bill 1463.
Chairman, I move to report with technical amendments.
Second. All right, we'll go to the voting board. Bill reports 8-0.
Mr. Chairman, members, thank you very much. Appreciate it.
All right. Yeah. All right, I see Delegate Carr. I think she's been here the longest. And I would like to thank the committee for their indulgence on taking the two wrongful incarceration first. Delegate Carr, you have the floor. It's House Bill 1738.
Thank you, Mr. Chairman, members of the committee. 1738 ensures virtual public access for public meetings of state and local bodies. Our Commonwealth, as you know, consists of diverse regions with unique issues and voices. Moreover, we serve Virginians of all backgrounds, with all ranges of work schedules, levels of physical mobility, and varieties of personal responsibility. Although I'm sure none of us would like to return to that remote session, our 2021 session did offer proof of concept for giving voices and access to all our constituents. Beside our own legislative session, ensuring that public access and comment is a vital step in transparent and engagement necessary to make our government, both state and local, operate in an efficient and accountable manner. This bill was brought to me by several constituents. I hope the committee will consider reporting this favorably.
All right, questions from the committee for the patron?
Chairman, I move to report.
Second.
We have a bill, House Bill 1738, properly seconded. Members go to the voting board. Delegate Carr, your bill reports out 8-0.
Thank you, Mr. Chairman, members of the committee.
Delegate Watts.
Thank you, Mr. Chairman, members of the committee. House Bill 2411 deals with the representation of individuals who are in mental health crisis and need representation in the detention order proceedings. The bill raises the fee for court-appointed attorneys from $75, which was set 25 years ago in 1998, to an amount that is equal to what is received for court-appointed attorneys who are representing criminal misdemeanors. So it is set at $120, and the commensurate percentage increase is made to the other fee. Let me just take one moment to address why this came before me. I think you all know what we have tried to do over a number of years to get proper representation for people in mental crisis. We have a serious problem throughout the Commonwealth. And in that representation, trying to get them the help that they desperately need. And what we find in my particular jurisdiction of over 1 million people, we only have just 4, sometimes 5 attorneys who are available for over 1 million people. And as the judge reached out to me, let me just read her words. It's been very difficult to obtain attorneys to represent respondents, and we are down to just 4 or 5. We've tried to obtain private attorneys through the Bar Association without any luck. We sought feedback from the attorneys who are doing the work to determine the issues and learned how hard they work. They must work Sundays and meet clients at the hospitals to prep for Monday and review their records, and then again each day/evening for the next day. Hearings are now disjointed, so attorneys clear most of the day, but may end up with minimal hearings for compensation or have a day full. It's hard to maintain a private practice for these attorneys. Again, I hope it'll be the will of this committee to raise the fee that has not been touched in 25 years.
Right, thank you, Delegate Watts. Any questions for the patron? And do we all understand the measure?
Mr. Chairman,
Yes, sir.
I move to report.
Second.
All right, we have a motion properly moved and seconded on House Bill 2411. Let's go to the voting board. House Bill 2411 reports out 8-0.
Thank you so much, Mr. Chairman, members of the committee.
All right, I see Delegate Williams-Graves, 2317.
Good morning, Mr. Chair and members of the committee. House Bill 2317 is for jury duty pay increase. Jury duty pay increase has not increased in 30 years, since 1993, when it went from $20 to $30. And I do believe that there is a substitute amendment, an amendment. Okay, thank you so much.
Chairman, I move approval of the amendment.
All right, all in favor, say aye. Aye. And the amendment,
Moves jury duty pay from $30 a day to $50 a day, as opposed to my original request, which was $100 a day.
all right. Any questions for the patron? All right,
Mr. Chairman, I move to report as amended.
second. All right, we have a motion properly seconded on House Bill 2317 to report with, as amended. We'll go to the voting board. All right, bill reports out 8-0.
Raised
sir.
persistence pays off.
That it does. Thank you.
All right, so now we'll go back to the beginning of the docket, and Delegate Marshall has House Bill 1412.
Thank you, Mr. Chair. House Bill 1412 increases from 2 to 3 judges in a number of authorized general district, and this is basically in district number 22, and I think it is recommended in the Committee on District Courts.
All right, any questions for the patron on this bill recommended by the Committee on District Courts, House Bill 1412?
Mr. Chairman, I move to report.
Second. All right, bill's properly seconded. Everyone go to the voting board, please. Bill reports out 8-0.
Thank you.
All right, House Bill 1591, Delegate Davis, would staff please present the bill, I think. I don't see.
Yes.
Is there a substitute, or what do we have in front of us here so we can?
There is a substitute.
Second.
All right, so the substitute's been properly seconded. If we could all vote on the substitute?
Aye.
Aye. All right. So the substitute's properly before us.
Yes, sir. This bill would repeal a sunset provision for the Office of Data Governance and Analytics that was created in 2021. Both that office and the position of Chief Data Officer, when created in 2021, had the sunset date of July 1, 2023. The substitute, as just recommended, reinstates the sunset date, but extends it 1 year to July 1, 2025. Additionally, the substitute would extend it by 1 year a report that was due by November 1st, 2022. I understand that the report actually was provided, so would suggest perhaps only adopting the amendment that extends the sunset date and not the amendment to extend the report.
So we need to sever the amendments, is that correct? Vote on one, the first?
That's yes. Josh, does that work for a substitute? Yes, correct.
Mr. Chairman,
Yes, sir.
Andrea, I thought you said 2025, but the one in front of us
Oh,
is
2024.
Okay.
Yes, sir. 1 year.
Okay, so if my understanding is correct, the first amendment, is suggested that we adopt. Do I have a motion on that first amendment? Just the substitute?
The first enactment clause in front of you.
Okay, thank you. So we need to adopt the substitute with the first enactment clause that's in front of us. Is that correct, Josh? Okay.
Thanks, Josh.
So moved.
All right, got a second? All those in favor say aye.
Aye.
All right. So now the new substitute is properly before us, which moves the one date and not the second date.
Yes, sir, correct. Extends the sunset date by 1 year.
All right, any questions for staff on the bill? Anyone in the audience like to speak in favor or against the bill? Hearing none?
We got a lady coming forward.
Yes, ma'am.
Yes, I'm Deputy Secretary Joyce Reed from Administration, and this office is under Secretary of Administration, and I just want you to consider that in the data governance area, this is one of the hardest areas that when you establish a team to start working it and to keep those positions filled, the importance of knowing that protecting, assessing, maintaining, and sharing that information and developing a portal I've been here with 1 year with this initiative, and it was already on the books. And I can tell you the team that has come together to establish and put this into place for the Commonwealth of Virginia is a hardworking and valued asset. So as you're looking at this year and reading the report, I ask that as you consider the report this year and we come back next year, you'll be ready for that government and that office to be a continuation and sustaining base, because they truly are your information authority and helping people share their information as established for the Commonwealth. So thank you for your consideration for the extension, and we appreciate it.
Thank you.
Mr. Chairman, I move to report with substitute.
All those, well, let's go to the voting board. House Bill 1591 is properly before us as substituted. House Bill 1590 reports out. Which one do we have next, Weber? Yep. All right, the next bill in front of us is House Bill 1758. Okay, so if we could have staff present the bill, please.
Yes, sir. House Bill 1758 would establish a Virginia regulatory sandbox program to be administered within the Department of Planning and Budget. The program would allow an individual or business to demonstrate a product, production method, or service under a waiver or suspension of one or more state laws or regulations. The bill sets out the process by which an individual or business may apply for participation in the program, the role of DPB in reviewing such applications, and the requirements. The costs of the bill are indeterminate, but anticipated they could be significant as it creates a new program that requires additional staffing and resources, not just at DPB, but likely throughout state government at other agencies that also have regulatory responsibilities.
All right, thank you. Any questions on the bill for the staff? Okay, and I think, is there someone online like to speak in favor of the bill, or Delegate Weber? Like to, your bill is before us.
Basically, what it does is it creates a small section of regulatory leeway so that new industries can basically have small pilot programs to determine how relevant they are, or if any new regulations need to be done or moved around. It was and allow for getting the policy right on emerging technological innovations. There have been several states that have done this: West Virginia, North Carolina, Hawaii, Colorado, and Utah have all created sandbox programs, and so that's the effort that we put forward in the bill in order to be able to do
Just
that.
a question for the delegate.
Yes,
the
sir.
cost is indeterminate. Do we have any idea what it costs in these other states to run this program? Because it looks like to me you would have to have layers of some bureaucracy.
What we have, we put in a budget amendment for $130,000 for two, for a slot for two people to be able to administer.
$130,000 apiece.
Roughly, yes.
Roughly. Okay. All right. Thank you, delegate. Any other questions for the delegate? I think there's someone online.
Thomas Turner for Conservative Clean Energy, speaking in support of the bill.
Yes, sir. Go ahead.
Thank you, Mr. Chairman, members of the committee. We support this bill, which gives agencies the tools to responsibly adapt to the rapidly evolving technologies which benefits the Commonwealth, whether it be related to energy or some other technologies are quickly evolving, and this legislation will allow the state to identify ways to quickly test and take advantage of them to drive lower costs and increase benefits to citizens rather than getting bogged down with red tape. And we appreciate Delegate Weber's leadership on this and on this issue.
Thank you very much. Any other comments or questions about the bill? Hearing none.
Mr. Chairman, I
Bill.
have a motion at the appropriate time.
Yes, sir.
I move to lay the bill on the table.
All right, we have a motion. All right, we have a motion seconded to lay the bill on the table. House Bill 1758. All right, the bill is laid on the table, 8-0.
Thank you, Mr. Chairman.
Work on it a little bit, delegate, and bring it back to us.
What's that?
Work on it a little bit and bring it back to us. Good idea.
I'll work on a bigger
We
amendment.
just need to know what it costs. Thank you.
All right. I think the last bill before us, is that correct? House Bill 2016, Delegate Adams. If staff could present that, please.
Of course. House Bill 2016 directs the courts to appoint 2 attorneys in any case in which an indigent defendant is charged with a Class 1 felony. Currently, only 1 attorney is appointed, and there's different provisions in the bill for whether the defendant is located in an area with a public defender office. So you would either appoint 1 from a public defender's office or 2, depending on the location. The cost for this bill is approximately $390,000 based on expenses for similar charges in fiscal year '22.
Thank you. Any questions for staff on House Bill 2016?
Chairman, move to report.
All right, the bill is properly seconded and is in front of us. All right, House Bill 2016 reports out 8-0. Thank you. And I think that concludes the work that's before us today. The committee shall rise.
Thank you. Thank you, Robert. Thank you.